my lady. I just wanted to double back to a good couple of points from this morning. The first of them is Lord Justice Burse was looking at the enlarged photographs and making certain observations in relation to those signs. Those signs are dealt with in 64 of the judgment and 67. And the judge, just to be clear, that the judge found all of those signs to be branded use, to be distinctive use, in part at least. The one that he didn't find to be distinctive use was the creator page, which you'll see on page 2, sorry, page 4 of the 5 of the non-paginated handout, the Pixar page, where you have home videos shorts written at the top. And in relation to that, we simply say that would require the person to perceive the word differently there from how it is on the left and how it is on other pages. But
presumably, Mr. Malnish, looking at that page, the answer to the question you're talking about is that you're entitled to take into account the fact that it appears in that row, home videos, live, playlists, community.
Yes, and indeed, if you click on it, then you're taken to a shorts only page. But I just wanted to just make the point that the judge found that all of those signs, including the one most importantly on the scrolling screen on a mobile platform, was a trademark use. The other point I wanted to show you, and it's getting ahead slightly into the 10.3 appeal, is to show you paragraph 256.
Just one thing, I'm going to try and only say this once, Mr. Malnish. You shouldn't assume that just because you think that I know what you mean when you say the 10.3 appeal,
yes,
everybody on the bench knows what you mean.
Exactly. I was going to open it more fully, and of course I showed 10.2b to the court this morning, and I'll have to show 10.3 in a moment. But it was on this point about whether there was any factual finding as to the portion of consumers who would have in their minds the predominant meaning. And it is, as I said, in somewhat there in paragraph 256. Because in that paragraph, the judge is considering the 10.3 argument, and I'll come back to the particular requirements of that. But the factual finding is, in my judgment, for consumers amongst whom SIL's marks have a reputation, i.e. consumers of short films, Google's composite signs would principally bring to mind short films, and where the signs include the YouTube name or logo, YouTube. However, because of those consumers' familiarity with SIL's marks on balance, I think it likely that they would also bring to mind SIL's marks, though in a less strong and immediate fashion. So, without getting into the specifics of the portion of people, what the judge there is finding is that some people will react by having in mind, now that's not confusion, but having in mind the SIL marks, the dominant, what we say the dominant meaning. So let me just go back to the submissions that I was making based upon the validity of the 383 mark. I have two further strings to my bow in that respect, and that applies not only to the 383 Shorts TV word only mark, but it also applies to all 4 of the marks, earlier marks, which is that first of all, we say that they have been used and have acquired a distinctive character as a result of the use. Now, the judge didn't need to find that because he held that they were inherently distinctive. But we say that there was a acquired distinctiveness, and my learned friend Mr. Selmy will be exploring that in a bit more detail. But I also rely on that for the purposes of reputation. Now, if I could just explain what I mean by reputation in the context of section 10.3. Section 10.3 the judge, I think, did actually, yes, 68 of the judgment. Oh yes, there's the provision. 68, paragraph 244. I'll just leave that for the court to digest. It's the extracted section from 10.3. Now, the first most important qualifying aspect is that there be a reputation, and the judge held there wasn't a reputation. We say that there was, and for the same reasons that there was an acquired distinctive character. In essence, we say we were a major player in a niche area, and that was the judge's error in this respect, that he was pitching the potential market far too broadly. Trademark specifications are often expressed in quite general terms. One might have a registration for clothing, but the only thing one has sold is wedding dresses. One can be a leading supplier of wedding dresses, and that doesn't mean that you get judged by virtue of the high street sale of casual clothing. Likewise, if you have a trademark for cinematographic films and you are active in a very small corner of it, an inherently modest corner of it, namely short films, your evidence should be approached on that basis, and the judge ought to have done that. There's an annex of evidence in the supplemental bundle. This is a document that was prepared upon the judge's invitation. Just to find that for you. It's tab 9, of the supplemental bundle. And what that does is it lists the marks on the left, use in the UK, and the use in question. It has the claimant's comments and the defendant's comments. And without the time available grinding through that, what we say is that all of the use related to the short film segment, so to speak. It comprised production, it comprised the promotion of the Oscar shorts, which is the most well-known short compilation in the world. But of course, even then, it's a very niche operation. It was showing in something like 30 cinemas, and 900 tickets, I think, were sold as evidence of that many tickets being sold. That might seem like a small amount, but in the context of the short film world, that was not a small amount. We'd been doing it for some time. We had linear TV channels, advertising supported channels, sales from iTunes. We had an app. Reputation is not an onerous requirement. That has been well established. It is simply a matter of establishing that you have enough reputation that people within that reputation will make a link such that there can be dilution and harm and so on. And we say that the judge's approach to this question was wrong. One of the things that he did that was curious when it came to the establishment of our reputation was, and this point also comes up when it comes to our fallback specification, and I'll explain what I mean by that in a moment, was that he defined the market at large as the general market, the general film goer market. But The reason for rejecting short films as a potential market was that he said that that category was inherently uncertain. It was too vague to amount to a definition of the market. There's no legal support for that approach at all when it comes to defining the market for the purposes of reputation, and the judge didn't cite any case law in support. It's wrong in principle because it just means that no specialist provider of goods or services with a trademark expressed in general terms will ever be able to establish reputation, even if they are an absolute success and commercial leader in that segment. But as I say, there isn't any reason to use the legal certainty of the term as a basis for denying reputation. That's the first point on that. Now, let me, I think that's probably just in terms of section 10.3.
Just on that, Mr. March,
Yes.
as I understand it, and correctly, if I've misunderstood, the judge thought that the Sazerac decision by Mr. Justice Fancourt was a decision that made exactly that point. But you're saying it's wrong.
Not quite, because it wasn't. Sazerac did adopt a narrower basis, but it did not adopt it for the reason the judge adopted it here. The judge here.
But just to be clear, if we just pause for a second. I mean, Sazerac's there at 248 in the judgment. And as I understand it, which is what the judgment says, the registration was for whiskey. The claimants claimed they had a reputation for bourbon, which was obviously a kind of whiskey, but not the only kind of whiskey. And the judge decided that in order to satisfy 10.3, the reputation had to be for whiskey, and the reputation for bourbon wasn't good enough.
Yes.
Which is rather similar at any rate to what the judge decided, isn't it?
Not so, because the reason given, I mean first of all, the point raised by the judge in Sazerac is obviously not binding upon the court here, and does not find its way into the Court of Appeal in that case. And it's very, we say, it's simply not correct as a matter of principle. But more importantly,
the judge below? I mean,
more importantly, my lord, what we don't have in Mr. Justice Fancourt's decision is any finding that, for example, bourbon is not a genuine category of goods, whereas that was the finding here. Short films is not a genuine category of goods. Yeah, and if you look at 250, even the judge in this case says that these cases provide no basis for a suggestion that for a trademark to have a reputation for the purposes of 10.3, it needs to extend across the breadth of the specification. So he didn't rely on that. But what he did do at the end of that paragraph, in my judgment, whether it's possible will depend inter alia on whether there's an identifiable subcategory of goods and the relative size of that subcategory. And that's what he holds to be absent in this case. He holds that short films is not an identifiable subcategory. That's consistent with his finding on the fallback, which I need to address you on as well. So that's why I was proposing to deal with these 2 points together. So the fallback arises this way. If a mark is to be held, and I'm talking about the validity of the Shorts TV mark, of course my learned friend Mr. Selmy will address the other four. But in relation to the Shorts TV word only mark, we said, well, even if you were to hold it invalid, the size of that hole can be managed, leaving a sufficient amount of the trademark that remains registered for similar goods and services to those covered by the use. And the fallback specification that we proposed was, cutting through some of the complexity, was save for short films. So shorts, if you delete short films from the specification, what you're left with are goods and services that remain similar or even identical to the services in question.
Are we, I feel that's one of the oddest parts of this case. Your case is that shorts means short films, your business is short films, and you're now telling me it's a virtue.
It's not
You
a
can
virtue.
get your registered trademarks, yes you are, by saying except for short films, which is the one thing you say your mark means and the one thing you say your clients do.
Lord, that is perfectly permissible under the law of trademarks to surrender effectively part of your
Well,
specification.
it may be perfectly permissible to surrender part of your specification, but for you to be standing here saying that's what it means and that's what you have to take out and that's what my clients do is surprising.
Well, it may be, but the point is, one has to look at I suppose it's like amending a patent to avoid validity concerns. It's the same issue. You are amending the trademark specification to avoid validity issues, if and to the extent necessary. This was a fallback specification. It was not our principal case. We say Shorts TV isn't descriptive of anything. So, that's our fundamental point. Plus, it's been used. So our fundamental arguments are those. This is a worst case scenario. We say what you've got to do is delete the bit from which it's said to be descriptive if it gets home that it's invalid and descriptive, right? So if that's right, then that's open to us in principle, right? So let's say, for example, we delete films, say for short films. That would leave non-short films, but it would also leave things like computer software. It would leave telecommunication services, right? Because for those we say the word's plainly not descriptive, right? So it's only if you take a very expansive view of descriptiveness, which the judge did, and say, well, it means anything that could have anything to do with short films. So that would cover also your telecommunication services, your computer software, because computer software could be used in the accessing and transmission of short films as much as anything else. But that, in my submission, is going way too far, because the trademark has to be assessed in terms of the immediacy of the descriptive message that is beaming out to the consumer when they see shorts in relation to computer software. Party applied for computer software tomorrow under the name shorts. It wouldn't be considered to be computer software for the purposes of transmitting short films. That's essentially the argument. So the only point I wish to make here, and I know I have limited time, is that the judge held that exercise was in principle open to us, but again did not find short films to be a coherent subcategory. So that's the argument that's before the court that the court needs to determine. And we say that comes up under reputation, under the Sazerac type dispute, but it also comes up under our fallback. I know that this is getting into the weeds of trademarks law, but essentially we say the judge was wrong. There is nothing uncertain or unclear about short films as a category. It's a very well established category of film. There is, of course, some uncertainty at the margins, like there is with all terms used in trademarks, but that is not sufficient to undermine the basic core meaning.
Mr. Barnett, can I just make sure I understand your submission, which I know you say is not just a disagreement with the judge on the facts? And you said it's sufficiently clear, but a few moments ago, I think you were criticising the judge for rejecting it as too vague or uncertain. So what is the certainty requirement you say exists?
So this does come close to being a challenge to the assessments, but the test is, as set down by Lord Justice Arnold, Mr. Arnold, I think he was, in the Omega case, which is that the term must describe a characteristic without changing the fundamental nature of the goods. And that is precisely not the case here. Short films they have their own ecosystem. They have their own festivals. They have their own prizes. They are not simply a shorter film. They are a specific genre. And of course, there may be debates about whether this documentary is a short film or not, or whether this clip or whatever is a short film. But that's not to say that people don't know what they're talking about. I mean, if you look through Google's own
I
schedule.
think
Yeah,
we'll
yeah.
probably need to make, I've got your point,
Got my
but
point,
the
yeah.
point
the-
against you is that that's just part of the judge's assessment.
I can see that, but the judge didn't apply that criterion correctly. He approached it on the basis that he thought that short films, because there was uncertainty at the margins, that undermined the entire category. And that's not right, we say. If you look through the annex, the green, red, orange annex, you have pages and pages of people talking about short films in a way that Google themselves knew what they were talking about. And indeed, in their own skeleton argument, they accepted in opening that it was a sufficiently clear and certain term. That's in you can see that recorded in the supplemental bundle. It's page 181. It's, if you look at line 20 to page 181, it's over the page, yes? Line 15. Now we say that is what Shorts is talking about, and perhaps comforting, this is me talking, it's also my learned friend's initial position, at least when it comes to validity. So if you look at her skeleton in paragraph 4, it says, the word shorts is commonly used by the public generally and members of the trade to describe short films. There's a plethora of evidence described below to support the proposition that the word shorts is used and has been used for many years by the entertainment industry, the public, and Shorts International itself to describe this particular type of content. For this reason, the trademarks are invalid. So that was the point that was being made. The factual premise was still being advanced. You knew what you were talking. This is purely a question of do people understand what it means? And they did. And indeed it was common ground that it was the short film. So it didn't make any sense for it to be then somehow to be removed or to be illegitimate as a category term, either for the purposes of defining the market or for the purposes of the fallback. Just on 10.3, the dilution ground, I mentioned at the outset that the judge's own finding is a finding of dilution in all but name. And that is in paragraph 258 of the judgment. If I could just show you that quickly. The section 10.3 action requires a reputation, a link, and then one or more forms of effect. The three being dilution, unfair advantage, and free riding and tarnishment. This particular case was concerned with dilution, which is where, as a result of the defendant's use, the claimant's mark loses its capacity to distinguish. We say this was a case in which there was an extreme form of dilution. It wasn't simply the addition of water, it was the swamping, the total overwhelming use that was made due to the size of the defendant and the change of the meaning. Now, that, we say, is supported by the judge's own finding in 258. He says, the distinctive character, such as it is, arises from the particular combination of the word shorts and the play symbol, and that has not been affected, he says. I accept that Google's activities have had the effect of increasing the use of the word shorts for one type of short-form audiovisual content. Vertical format, less than 60 seconds, generally user-generated, and so moving the center of gravity of the use of the word shorts away from short films, That change in the weight of usage of the word may mean that SIL now has to explain its business more than it had to previously, but it does not mean there's an effect on the distinctive character of SIL's mark. But having to explain its business is exactly an effect on a dilutional effect. Changing the centre of gravity, that acknowledges that the centre of gravity prior to Google's use was short films, and the centre of gravity after Google's use was user-generated 60-second content, vertical format. That's material. That is significant.
Why is it material? That's got nothing to do with trademarks. That's just the meanings of words.
Yes, but in this instance, that's the part of the message of the trademarks. Part of the message of the trademarks is to be elusive and to be suggestive of the content. Why that? And if that is subverted, that makes that message, the suggestive and elusive message, all the more difficult. And in fact, the judge is actually acknowledging that we have to actually do something in our promotional efforts to unravel this problem, or to explain this problem.
Let's say I had a trademark lintel.
I'm sorry, lintel.
Lintel.
Yes.
And I sold a drink called a lintel. And of course the point is that the word lintel means a thing in a building that goes above a door. And somebody started selling a different kind of lintel, which worked for different sort of doors or something. I don't know, a concrete lintel instead of a metal lintel or something. Mm-hmm. And they changed the meaning of the word lintel, which caused a shift in the centre of gravity of my drink's trademark.
Yeah.
That would not be an infringement under section 10.3 on any view. It would be nothing to do with trademarks.
Because it's purely a language evolution issue.
Exactly.
That may
This is
be,
about the descriptive use of the word.
it's true that language must be allowed to evolve, but in this case, Google's use is branded use. It's
The
branded.
judge's finding is that he starts and says that the distinctiveness, which is of course what is the trademarkiness, is not affected, and then he describes a change which is about the meaning of words.
Yes. We say that given that he's found that the Google use is branded use, which also carries an elusive meaning, so a suggestive descriptive meaning, and that is changed, and that has a negative effect on us. The negative effect being it requires us to expend money and time explaining the situation, which we didn't have to do before.
Right.
That is
Why
an
is that not
effect.
exactly the same as the lintel example I'm giving you?
Because absent that conduct, my lord, my trademarks would be unaffected. They wouldn't have to face this problem. So it is an effect on my trademarks. And it might be said that
The point is, what the judge has said is it is an effect on you, but it is an effect up with which you have to put, because trademark law is not designed to
I
protect you
suppose
from
the
it.
difference is we shouldn't have to put up with that.
So you say, Mr. Malish, but I'm trying to understand why you're right about that.
Well, because in most circumstances, the defendant's activities are most unlikely to change the meaning of a term. The lintel example, as you say, the scale of the use to change the term in the public mind would have to be vast. And that's exactly what's happened here. It's vast.
Yes, no doubt.
And to that extent, it has the potential to swamp the meaning and the elusive meanings of our marks, but also to the advantage of Google. It's not put on the basis of free riding, but it can be an effect that has, that obviously they're interested in making it mean them as a brand, and the negative effect of that on us is impact on our mark, on its ability not only to describe and allude, but also to distinguish, because of course it now means Google. It
That's not
now,
what the
when you
judge
do a
said.
search,
Mr. Malish, I mean, what you just said is not what the judge found.
well, when he talks about the centre of gravity, the planetary dynamic going on there is pretty significant, we say. Very unusual in trademarks that you would have that. And that is an acknowledgement, we say, not only of that, but also of the fact that it had an effect, and we had to do something about it. Anyway, that's all I'll say on that. I may have come to I'm just checking my notes to see. The only last point I wanted to, and this is probably a good point to make before my learned friend opens, which is the relationship between validity and infringement. We say Google's case on validity is in marked contrast to its case on infringement. It relies upon the stylization of the marks in order to say that the marks, the sign was sufficient to escape infringement, but then of course describes those stylization aspects as a fig leaf when it comes to validity. Now, there is a difference between the two analyses in the sense that, as I say, one is concerned with a symmetrical descriptiveness. It's two, a mark and a sign have to be assessed in terms of descriptiveness, whereas validity is only concerned with our mark. Whilst we acknowledge that there could be said to be a tension in our position, we say our marks are inherently distinctive or else have acquired distinctiveness. And on infringement, the point is not that shorts is inherently distinctive, but that it's not purely descriptive to a significant proportion of consumers in the context of Google's specific use. So these are consistent positions, we say. Anyway, my learned friend Mr. Salmi will address validity in response to the appeal that is put, and I hope those are my submissions, unless my lady have any further points for me.
My lords, my lady, the judge said at trial on a number of occasions that this case was a bit like an exam question because of the number of different issues it raised in relation to infringement and validity. Now, obviously, we say that the judge got full marks in this exam, but I do want to attempt to assist my lords and my lady with the many issues in the judgment. And I'm going to take it in the following order, which isn't quite the same as my learned friend. It's pretty similar. So first of all, the issues on Short's appeal, and they start with the infringement issues, if I can put it like that. And they are the meaning of the word shorts, although as I'll come on to, that's not really properly a freestanding ground, but it does run through many of the points that the judge had to decide, so it's helpful to look at it first. Then there are various points on the comparison of the marks and signs. In particular, my learned friends point that the judge allowed distinctiveness to pollute the comparison. Then we get to the points on the overall assessment of likelihood of confusion. And I think the key one on that is in relation to what my learned friend says is the wrongful emphasis placed on the play symbol. Then we've got section 10.3. So there are essentially four different headings that we've got to look at for the purpose of the appeal on infringement. I'm then going to take the appeal on validity of the 383 mark at the end of my submissions on infringement, because obviously, as my learned friend acknowledged, in relation to the 383 mark, that's the word mark Shorts TV, the judge found that that was invalid, and we say that was absolutely correct. Then we turn to our cross appeal, and that relates to the validity of what I'm calling the 2018 marks, and so that's all the stylised marks. And that falls under two heads, and obviously my lords and my lady haven't yet been addressed on that because it's my appeal. But the first head is distinctiveness, which does have some general overlap with some of the points on Short's appeal. And the second head is non-use. Now, there are a number of points in relation to both infringement and validity where, at least in its skeleton argument, Sill says that the judge should have decided that its marks had a reputation and or had acquired distinctiveness on the basis, they say, that his findings of fact were not right. Now, I'm not entirely sure the extent to which my learned friends are pursuing that, but my learned junior is going to deal with the appeal in relation to the factual findings about acquired distinctiveness. From what I've gathered, it looks as though that point is only being run by way of the respondent's notice on our cross appeal, and I say that because I didn't understand my learned friend in opening his appeal to make some of the points that he did make in his skeleton argument, suggesting that the judge had come to the wrong conclusion in relation to acquired distinctiveness, for example, on the validity of the 383 mark. And that's ground two of my learned friend's appeal. And I am, I'm afraid, going to be a bit boring and try and take you to the actual grounds of appeal so that we can see where we're going.
When you said the judge got full marks in the exam, you mean apart from where you say he was wrong?
Yes, well, I was about to come to that point, my lord. And what I want to say about that is that our primary position is that the judge was right for the reasons he gave, that there was no infringement in this case. And more importantly, perhaps, we say that the judge reached the correct result. That taking a step back in this case, the correct result is that Google shouldn't be liable because it is using the descriptive words shorts to describe its short form video sharing service in a context that makes it clear that it comes from Google. And there are two ways to arrive at that result, essentially. One way of arriving at the result is the way in which the judge did it in relation to infringement, to find that there is no infringement. And another way of arriving at the correct result is to find the marks invalid. And as I say, our primary position is that the judge got it right in the way in which he did. But the reason that we're running a cross appeal, just to be very clear, is first of all because occasionally reasonable minds may differ on these descriptiveness cases as to whether the way of reaching the right result is to find that the marks are invalid or to find that there's no infringement. And the other reason is because, in fact, as my learned friend pointed out, one of the points that he takes on his appeal is that the judge placed undue emphasis on the play symbol when he was considering the question of infringement. Now, if my lords and my lady were to find that that point is correct, in other words, the judge should not have placed the emphasis that he did on the play symbol in the context of infringement, in my submission, the upshot of that finding would be that he shouldn't have placed the emphasis that he did on it in the context of the validity of the marks, and therefore it would follow that the marks are invalid. And so that's essentially two reasons why we say the appeal, the cross appeal is appropriate. First, because there are sometimes two ways of reaching the right result in these trademark cases, and secondly, because one logical conclusion were, my lords and my lady, to find in favour of one of the points that my learned friend makes would be that the marks are invalid.
So you say your cross appeal is essentially responsive?
I do, yes.
So you did appeal independently?
Well, I did, and the reason I appealed independently is because that there are findings in the order that the marks are valid, and so there is a something I have to appeal against. I mean, I couldn't just have raised them as a respondent's notice if that's the point that my lady's making. As to why the appeal should fail, in my submission, it's pretty clear, although my learned friend has done his valiant best to say that there are points of law that the judge got wrong, in reality, when I take my lords and my lady to this judgment in detail, which I intend to do, my lords and my lady will see that, in fact, the judge set out the law very clearly and carefully, and my learned friend essentially is not challenging his summary of the law in pretty much any respect at all. And he then applied the law to the facts, and he either did that by way of a multifactorial assessment and evaluation, which, as my lords and my lady will appreciate, is not something that can be meddled with lightly in the Court of Appeal. And so many of my learned friends' points are criticisms of the multifactorial assessment. And the others are, I'm afraid, appeals against findings of fact, which my learned friend doesn't like. And as we go through, I'll explain which category they fall into. So starting with the meaning of the word shorts, which happens to be ground one, although it is perhaps worth just briefly turning to the grounds of appeal, and that's tab 7 of the core bundle, page 249, and seeing what ground one is here. It's said to be that the judge erred in failing to hold that in the context of visual entertainment the preponderant meaning of shorts was short films. Well, that is exactly, in fact, what the judge did hold. I mean, he recorded the fact that it was agreed between the parties that the predominant meaning was short films. But let's go to the judgment, starting at paragraph 46, which is on page 16, tab 1 of the core bundle. And obviously, if I'm taking this too slowly at any point, or my lords and my lady feel I need to be hurried along, please do hurry me along. Paragraph 46 records the position of Sill at trial as to the meaning of the word shorts, and that is that short films are just like feature films on theatrical release, but shorter. And in particular, a point that my learned friend hasn't really emphasised, but was very important at trial, is that it's said that they share with feature films the characteristics of having narrative structure, a plot, scenes and actors, and having or aspiring to have professional-looking production values. So this was what Sill said at trial was the meaning of shorts. And then we had some evidence, this is at paragraph 47, on behalf of Google from a Mr. Harbinson. And he was the distribution and partnerships senior lead for social and digital platforms. It's a bit of a mouthful at Channel 4. He was basically someone who worked at Channel 4. And he explained that shorts had been in use in the vernacular of the film, TV and broadcasting industry since before he joined the industry in 2014. He explained traditionally shorts were short films. However, he continued, the meaning of shorts has evolved over time from films traditionally made and viewed in a cinema to mean more accessible, even shorter digital content. What the judge records at 49 is the point I was just making, which is that the parties were agreed, in our case subject to the question of whether short films could be sufficiently clearly defined, that the materials in the case showed that the predominant use of the term shorts was to mean short films. However, the judge goes on to say that the parties were also agreed that the material showed a number of instances of use of the term shorts to refer to short form audiovisual content that was not a short film. And it's necessary to recall here, of course, what Sill said was a short film, and it's a pretty narrow definition. So it's like a feature film, but it's got to have a narrative structure, etc., etc. And then the judgment goes through some of the materials and explains how there are or were plenty of instances where shorts was not used in that very narrow sense of short films. And I'm sure that my lords and my lady have had an opportunity to look at this part of the judgment. But for example, paragraph 51, there's an online comedy short, Sending Up Brexit, which became a viral hit, racking up more than 10 million views. Then at paragraph 52, towards the end of the paragraph, we've got an article in the Times which talks about a series of TV shorts, contrasts it to short films. And then we've got the Telegraph, this is the end of paragraph 52, publishing a review encouraging readers to watch the explained Netflix shorts that cover topics from the rise of cryptocurrency to the world of K-pop. And then at paragraph 55, we highlighted the fact that a number of articles in our table of use referred to shorts on YouTube before the launch of YouTube Shorts. So, for example, the Telegraph reported on London drama Blue Story, whose YouTube Shorts have garnered millions of views. And then the Observer said the rest is to be found by digging through YouTube, Vimeo and other free platforms where his dizzy array of shorts, commercials and music videos are to be found. And so what you'll see at paragraph 56 is that, having looked through the tables, the judge concluded that the word shorts was being used to refer to short form audiovisual content which went beyond short films. And then, going on very importantly to paragraph 58, his conclusion was that as at each of the relevant dates, because there are slightly different dates depending on whether you're looking at infringement or validity, the meaning of shorts was not limited to short films, but also included other short form audio-visual content. And so, in other words, he accepted Google's case that the meaning of shorts had evolved beyond traditional short films. And this paragraph is very clearly a finding of fact, which it's not open to SIL to challenge unless it can show that it's plainly wrong. And in fact, to be fair to it, in its skeleton argument, SIL says in terms that it is not challenging this factual conclusion, although it does suggest that the judge made a legal error in extrapolating from a few outlying examples to the general meaning. We say that that's not right because he made nuanced factual findings, including summarising the parties' agreement. And in fact, it appears as though SIL's position has slightly morphed in its oral submissions towards saying that the issue is that the judge didn't make a finding about a particular segment of the population who, on SIL's submissions, understands shorts to mean traditional short films and nothing else. And the problem with that submission is that there is no finding in this part of the judgment, or indeed anywhere else, that there are people who would never understand the word shorts used in the context of YouTube to mean short form visual content rather than traditional short films. So what SIL needs to do is to find this group of people who, it says, see the word shorts in pretty much any context, but in particular in the YouTube context, and say that must mean short films and nothing else. And the reason why SIL cannot find that factual finding which it needs in the judgment in our submission is that there was no evidence that for people who understood shorts to mean short films, that was the only meaning. So we say that presents SIL with real difficulties when it comes to try and make the argument that it wants to make on infringement, where it says, well, look, you can't take into account the descriptive character of shorts in the context of YouTube, because you've got to think about that part of the population that wouldn't have understood it in that way. And I'm going to come back in more detail to that argument in a minute. But what I'm trying to do at the moment is just establish what the judge's findings of fact were in relation to the meaning of shorts.
Just on this finding of 58,
Yes.
of course, it's dawned on me that this finding presupposes a context, because, I mean, to my mind, the meaning of shorts, and what I'm thinking of mostly is the shorts that I might unfortunately wear in the summer.
Yes,
Now,
indeed, indeed.
The point is that that's obviously not what the judge is talking about, but the judge is clearly, and your submissions, and both of you are clearly talking about a context.
Yes.
And I just don't know what, now that's dawned on me, I don't know what the context is.
Well, my lord, it's fair to say that SIL's position at trial was that shorts had other meanings. I mean, that's reflected in paragraph 46.
Well,
When,
yes,
I mean, absolutely. But in my submission, the context must be the context of this case, generally in the broadest possible meaning, where we're talking about audiovisual entertainment, we're talking about films, and so on. So we're not talking clearly about the use of the word shorts on the H&M website or the Marks and Spencer's website.
Well, clearly not, but now it's dawned on me. I've just realised that there was a boundary somewhere that no one's actually articulated.
There's
Yes.
possibly also another contextual point, which is, possibly, I don't know if this is right, whether it's relevant that you might not expect to see short films in a way that SIL would understand them to be on a YouTube.
Well,
user-generated site, but that probably.
in my submission, you would have to have some good evidence about that, not least because YouTube is a very, very broad platform, and so the whole point about shorts is that the YouTube shorts bit is that it is these very short films, whereas in other places on YouTube you can see longer short films. So YouTube itself isn't just restricted to user-generated content. I mean,
yes, that was going through my mind. So presumably some professionally made films, if that's the characteristic, could find that way.
Absolutely, absolutely. For example, SIL itself puts things on YouTube, and indeed that was a bit of a problem with its tarnishment case, which it then dropped. But the point is, there's professionals on YouTube, there's amateurs on YouTube, there's everything in between.
Presumably there's adverts for H&M shorts on YouTube.
Well, quite probably, yes, my lord, in the middle of some shorts of the short film variety. So the second element that it's important to understand in relation to shorts and the meaning of shorts is to ask, what is the meaning of short films? Because that comes into some other parts of the judge's decision. For example, in relation to this question about the fallback limitation in post-cantor. And the judge dealt with what the meaning of short films is, or what SIL said it is, in the judgment from paragraph 60 to paragraph 62. And so he explains at paragraph 60, this is on page 18, that for reasons which will become apparent, it's also necessary to consider whether short films is a clear definition of a category of goods. And then he refers back to paragraph 46, which I've already shown you in relation to what SIL said. And he points out that there wasn't actually a consensus as to the maximum length of a short film. For the purpose of the Oscars, it's up to 40 minutes, whereas Mr. Harbinson said they could be up to 45 minutes. Then at paragraph 61, there's a question of, so that's really going to the point about short. And then there's a question of what makes a piece of audiovisual content a film. And SIL said that it was something with narrative structure, etc. And in fact, as the judge says in the second half of paragraph 61, the problem with Sill's definition is that, for example, it accepted that it included animations which have no actors, documentaries which have neither actors nor any plot, and he can't see why whether something has what could be called scenes or not affects matters. Further, whether something has or aspires to have professional-looking production values is a subjective assessment rather than an aspect of the definition. And then he talks about narrative structure and how that lies along a spectrum. And he says that's, again, a characteristic of the content rather than an aspect of the definition of a type of goods. I mean, it's interesting that on this appeal, Sill hasn't really attempted to define what it means by a short film. And really the problem, and this permeated a lot of what Sill complained about, particularly in relation to section 10.2 and 10.3, was that they didn't like the type of shorts on YouTube. And so Ms. Sharmail, who was one of the main witnesses on behalf of Sill, said, and this is paragraph 62 I'm looking at now, that the kind of content on YouTube Shorts was not a film because there's no narrative, no story, no serious filmmaking craft. The difference is the craft, the composition, the storyline, the acting or documentary content or animation, etc. In my judgment, this is not a proper basis on which to identify a category of goods as opposed to characteristics of the goods. And this is really important when it comes to, for example, the post-Cantor point or the point on section 10.3 about reputation, because there has got to be a definition of a clear category in order to do various things like, for example, work out what the market share is, because otherwise you've got no idea what your market is. If you don't know whether it includes, for example, very short shorts like the ones on YouTube, or you don't know whether it includes shorts that are made by normal people as opposed to filmmakers, how can you start assessing questions, for example, of distinctiveness, which the case law tells us you have to do by reference to market share, if you don't know what the market is? And so Sill is very wary, as I've already said on this appeal, of coming up with a definition, because every time it tries to do that, basically, it becomes very obvious that the definition is not clear and it is often very subjective. So turning now to what I perceive to be one of the main attacks that Sill is making, and that is ground 5, descriptive use. Now I do want to go to ground 5, so again, my lords and my lady can see what the ground looks like. It's in tab 7 at page 250, and ground 5 is that the judge wrongly regarded some of the allegedly infringing signs as purely descriptive and thus non-infringing. And just by way of sneak preview, I mean, I'm going to be a bit boring about this because this is an attack on two specific instances of use, and I'll show you which ones they are, and it's a complaint that the judge found that they were purely descriptive. Sill is now off on a frolic of its own, which, to be fair, is pretty apparent from the skeleton argument, but the frolic of its own is that it's now complaining generally about the judge's analysis of all of the different signs that we use, and complaining about the judge having found those all to be descriptive, but that isn't in its grounds of appeal. And it is actually important to consider these two different types of marks separately, because the judge came to different conclusions about them. So he dismissed these purely descriptive ones on the basis that they're not used in relation to goods. So then you don't even need to get to the assessment of the likelihood of confusion. Whereas the other ones, he had to look at and do the overall assessment. So I'll explain exactly what we're looking at as I go through this. But starting off with these instances which Sill complains the judge wrongly regarded as purely descriptive, they are in paragraphs 12 and 16 of the judgment. So paragraph 12 is page 6. Now, I don't know whether my lords and my lady have already marked up my learned friend's larger version, but if you're looking at the larger version, paragraph 12 is on unnumbered page 5, sorry, and it's the Pixar one. And so you'll see that there are two uses of shorts on this page. One is in the vertical menu, which has got the icon next to it, and one is in the horizontal menu, just underneath the sort of ball logo, the sort of beach ball thing. And what we're talking about is the horizontal menu for the moment, the one that says Home, Video, Shorts, Live, Playlist, Community. And then we also need to look in paragraph 16, which is over the next page, page 7, and it's a couple of pages on in the larger version, if we're also looking at the larger version, but it's the right-hand image of those two vertical images. And in particular, in the right-hand image, we're looking across the horizontal menu underneath the word Surfing Sydney at all shorts, videos, unwatched, watched. So at the moment, we're just looking at those
Sorry,
two.
I'm getting confused. The top right-hand side.
Yes. Does my lady see that it says Surfing Sydney in the search box?
Yeah.
Underneath that,
Oh,
all
sorry,
shorts.
I was looking at the bottom of the page. It's
Yes.
the top of the
So,
page.
oh yes, there are two horizontal menus. My lady's right. I'm looking at the first one.
You're looking at a mobile phone screen,
Yes.
as it were, with two.
Yes, but I'm only interested at the moment in the top horizontal menu that doesn't have an icon.
Yes.
Because these two instances are ones that the judge describes as purely descriptive. So I'll show you where that is next, in fact. That's in the judgment at paragraphs 171. Well, I'm going to start at 171, so that's the law, actually. So let's do a bit of law, not in dispute. Paragraph 171, section 10.2, 6 conditions must be satisfied for trademark infringement. And I'm going to highlight subparagraph 5. It must be in relation to goods or services which are at least similar to those for which the trademark is registered. So this is the use of the sign. And I'm highlighting the words must be in relation to goods or services. And the reason I'm highlighting that is because if we then look at paragraph 172, the judge records that Google reminded me that in order to be used in relation to goods or services, a sign needs to be used for the purpose of distinguishing goods or services, i.e. as a trademark as such, and that purely descriptive use of a sign does not amount to use of a sign in relation to goods or services. Although, he then points out in brackets, and this is quite important, a sign can be used both descriptively and as a trademark, and he refers to a case of Mr. Justice Arnold, as he then was. Now, if we then move forward to paragraph 224, which is on page 63, this is where the judge starts at the bottom of the page, identification of the signs and the context, looking at the signs that he's got to consider for the purpose of infringement. So this is Google's signs. And he starts at paragraph 224 with the particular examples that I showed my lords and my lady on in paragraphs 12 and 16. I shall start with the use of shorts in the menus on the creator pages. Here there was no dispute about the sign being used. The dispute was whether it was being used in relation to goods or services. I agree with Google's submission that the average consumer would understand shorts in that context to be being used purely descriptively to refer to the type of material rather than as a trademark, and so not in relation to goods or services. The same applies to the use of shorts on the I think I should say shorts, but anyway, on the creation tools page on the mobile app. So those are the two examples that I've just shown my lord and my lady, my lords and my lady. So paragraphs 12 and paragraph 16. So if you want to, you can flick back to those and see that he's talking about paragraph 12 is the Pixar is the creator page, and paragraph 16, it's really explained there that you get the shorts feed. Sorry, actually I think it might be explained over the page. So basically, this finding that the word shorts would be, the average consumer would understand shorts in that context to be used purely descriptively, we say is a finding of fact, which it's not open to SIL to challenge unless it can show that it's plainly wrong. And we say that they haven't identified any reason for saying that that decision is plainly wrong. And it picks up on the wording that I pointed out to you about purely descriptive and the law that we looked at before. And we say it's very clearly a sound decision, and one can see that it's sound by looking at the context in which the word shorts is used on the two different pages that we've looked at, because the context in the case of the website, that's the Pixar one, is that the other words are home, videos, live, playlist, community. I mean, they're all descriptive words. And similarly, when one looks at the other example, which was the paragraph 16 one, the words along the top are all shorts, videos, unwatched, watched. And so the fact that all of the other words are unarguably descriptive will mean that the user will understand shorts to be descriptive as well. And it's a question of the nature of the word itself and the context in which the user sees it. And indeed, I mean, in my submission, the court doesn't need anything more than that. But as it happens, there was also some other evidence in the case that showed very similar use by other third parties. And I won't go to that, but it is in our skeleton argument at paragraph 33, which is the core bundle tab 5, page 194, where we summarise at the top of the page that, for example, the Disney app on smart TV has a series of shelves which are series, movies, shorts, specials. Mr. Pilcher accepted that use of shorts by Disney was descriptive. Similarly on the Disney Plus website and the Film 4 website, and that's all summarised there. So we say that deals with ground 5 of SIL's grounds of appeal, because my lords and my lady will recall that is that the judge wrongly regarded some of the allegedly infringing signs as purely descriptive and thus non-infringing. And that reference to purely descriptive is clearly a reference back to the decision at paragraph 224, and there is nothing wrong with that decision for the reasons I've just explained. But I do accept that SIL's skeleton argument, and indeed its oral submissions, go further. And so in particular at paragraph 22 of its skeleton argument, it criticises paragraphs 225 to 229 of the judgment. Now, in these paragraphs, I don't know if my lords and my lady have that in front of you still, it's page at the bottom of page 63 of the judgment. In these paragraphs, the judge is going to look at the other uses of shorts by Google, so all the other ones in the hand up and in the judgment. And so what he says is that by contrast, in my judgment, when the average consumer sees YouTube shorts as a word mark or in a format such as that on the left below, they would understand that shorts is being used both descriptively to refer to the type of material, and in that respect not in relation to goods or services, and as part of a composite sign which indicates the origin of the goods or services. So he's now going on to look at all the other uses, and first of all he looks at the ones which are pictured at the top of page 64. He says that's used both descriptively and as a trademark. He says the same in paragraph 26 in relation to the signs shown at 226. He says the same thing in relation to those signs. It's in the middle of the paragraph. Again, in my judgment, the average consumer would understand that the word shorts is being used descriptively, but also as part of a composite sign. The same thing in paragraph 227. Again, it's the second sentence. And then finally, in paragraph 229, again, he says, these are the ones, my learned friend particularly likes the one on the right-hand side of paragraph 228, and that he finds is being used descriptively, but also as part of a composite sign, which operates as a trademark. Now, the complaint here is that the judge didn't consider the perception of shorts by this particular segment of the population to whom it is said the relevant public understands means short films. I might say that sentence again. What the complaint is there's this group of people, and when they see shorts in this context on YouTube, to them it only means short films of the traditional type. And they say the judge failed to consider that group of people. They say...
In this context, in the context of answering these questions?
Yes, that's the complaint, in the context of answering these questions. And I think I've already made clear that that isn't actually a ground that is in the ground of appeal. But we say that it's a bad point because the judge clearly took the view that the average consumer would view these signs as partly descriptive in the particular context in which they're used. So the judge has made a finding that the average consumer thinks that they are partly descriptive in this context. Now, my learned friends don't like that finding. They say the finding should be that when you see them in that context, they're not partly descriptive, or when the average consumer that they want the court to concentrate on sees them as in that context, they're not descriptive because these aren't shorts or these aren't short films, they say. It's the wrong type of short films. But we say essentially, again, this is a challenge to a finding of fact. I mean, the finding of fact is the average consumer understands this to be descriptive use.
Well, and also it goes back to the earlier point, I think, doesn't it? The point you started with, that there is no finding that a particular segment of people
Indeed.
view this as short. I'm finding it myself quite difficult to distinguish between these points. If you, in a sense, a finding that this is partly descriptive probably may assume that you don't think that the meaning of shorts is confined to professionally shot films.
Indeed, and it's completely consistent with the finding of paragraph 58, which is not challenged, explicitly not challenged, that the meaning of shorts was not limited to short films, but also included other short form visual
I
content.
think that's my point.
Yes, yes.
The bit I'm not quite sure about at the moment, Ms. Lane, is that does it necessarily follow that the judge had to find that the word shorts doesn't just have what I'm going to call a predominant meaning of short films, but a subsidiary, I'm going to use that word, it's not the judge's word, meaning of user-generated content? Was that a necessary precondition for the finding here when the judge is looking at the YouTube website to say that this is partly descriptive and partly trademark use? Because at the moment it doesn't feel to me that those two things have to relate to each other at all. I mean, I can't say I came to this case with any preconceived notion of what the word shorts meant, other than it probably has something to do with something being short.
Yes.
And I look at the Google YouTube material, and it's pretty obvious that the bits that have the word shorts with the little red icon are partly descriptive and partly trademark use. And that's said without having a preconceived view about what the word shorts means. It obviously is partly because it's all part of YouTube's branding, and it's also partly because it's describing short things.
I mean,
Do you have to already have decided that you think you know what shorts means in order to reach that conclusion? The judge is there at 2222 to 229. That's my question.
no, my lord, that's probably right in the sense that I would say we could win both ways. But as it happens, the judge did start by considering the meaning of the word shorts and concluded that it had this wider meaning.
Yes, but he doesn't say in any of those paragraphs. He doesn't link the descriptiveness, descriptively, I think he just puts it, to the meaning. He just says that it's being used descriptively, which I read when I read this the first time. I didn't think there was anything more to it than that.
Yes.
You agree with Mr. Malnish, as I understand it, that finding about descriptively is tied in to the finding about the word shorts having at least one meaning, which is user-generated content.
Well, that's certainly one way of reading the judgment, because he starts with the meaning of shorts, but in my
It's the right way
submission,
of reading the judgment. I mean, it's the way you seem to have been reading it up to now.
yes, but I'm now increasingly attracted by my lord's way of reading the judgment, as is always the case, of course. But I mean, in a sense, what my lord is saying is that, for example, when we look at paragraph 224, which is where we started, was the average consumer would understand shorts in that context to being used purely descriptively to refer to the type of material, is the point that my lord is making. I mean, the user looks at this.
You don't have to have any preconceived
No.
notion about what the word means when you look at that horizontal usage and see that whatever it is, it's something that's short, and it's descriptive use in a collection of all short video on watch.
Yes, indeed.
Anyway, all right.
I mean, to be fair to my learned friend, perhaps the fact remains that he would say, well, you've got to look at my particular category of people I want you to look at. And my particular category is this mythical category of people who only understand shorts ever to mean short films, even in this context. Now, there is one other relevant passage in the judgment to show my lords and my lady on that, and that's at paragraph 290 at page 79, which is actually in the context of passing off, but does shed some light, because he says, further in my judgment, users of the YouTube Shorts service will understand that the word shorts is being used to describe the nature of the videos forming part of that service. That applies even amongst the group of consumers amongst whom SIL has goodwill. SIL's reputation is, as Mr. Thompson said, blah, blah, blah. So he specifically addresses there this category, this segment, and says that even that group, i.e. the ones with whom, the film buffs who know about Shorts International, even that category will look at this and think this is descriptive. So in my judgment, that is absolutely supportive of the fact that when the judge was looking at the question of whether the marks would be, the signs would be understood partly descriptively, he did have in mind the point about, well, that there is this other meaning, there are people within the scope of Sill's goodwill and so on. And as I've already pointed out, it was never suggested by Sill at trial that members of the public for whom the predominant meaning of shorts was short films would think that that was the only meaning it could have in any context, or at least in the YouTube context. There was no evidence that that was the case, and in my submission that's simply not the way language works. I mean, it would be very surprising with a word like shorts to adopt the position that in any context you would only think that it's going to mean short films, the traditional type of short films. So in my submission, the judge was absolutely correct in the procedure he carried out in terms of looking at the signs and trying to understand how they were being used and whether they would be understood descriptively. So there is a ground for, I'm moving on to something else now, that there is a ground for in the grounds of appeal. I don't think it's really pursued, but I'm just trying to sort of tick them all off. And ground 4 in Sill's grounds of appeal is at page 250 of the bundle. The judge omitted to compare the sign comprising the word shorts per se, and I hope that it's accepted by my learned friend, and he didn't seem to be running a point on this, that obviously because the judge has decided that the signs used in paragraphs 12 and 16 are purely descriptive, he doesn't need to go on and carry out the overall assessment. So that sort of ticks that one off. We're then at ground 6, which is that, that's also on page 250, the judge wrongly allowed the criterion of distinctiveness to pollute his comparison of the marks. And this is where we get to look at some exciting EU authority, but I'm also going to show you some UK authority, which, to be fair, is a lot easier to understand. But we'll start with what the complaint is here, and the complaint relates to paragraph 232 of the judgment, which is on page 65 of the bundle. And what I'm going to start by doing is, I'm sure my lords and my lady have read this paragraph a number of times already, but would you mind casting your eyes again over paragraph 232 in order to notice, and this is really important, that the judge does spend a lot of time talking about the visual, oral and conceptual similarities in the mark, because my learned friend's submission is that he airbrushes out the similarities because he's so obsessed by distinctiveness. But that is far from a realistic summary of this paragraph of the judgment. I mean, he finds that there is visual similarity, first of all. He also mentions the visual differences. He finds that there are oral similarities. And then he says the conceptual similarities are also obvious. And the bit that the complaint is about is the last two sentences at the end. However, for the reasons I've explained, the word shorts is descriptive of the type of material, and the play symbol is an indication that the material can be played. So the similarities are at a level which differs from that which is given. The 615, 649 marks their distinctive character. By the way, we agree that he's got the numbers wrong in this paragraph. And so we say that this method of carrying out the comparison is absolutely correct as a matter of law. And if I could start by referring you to paragraph 174 of the judgment, which sets out actually the decision of Lord Justice Arnold in Iconics, but most importantly it sets out the general approach to the consideration of likelihood of confusion, which is absolutely standard. And if my lords and my lady look at subparagraph D on page 48, you'll see this is the what you have to do in relation to looking at the similarities. You have to says the visual, oral and conceptual similarities of the marks must normally be assessed by reference to the overall impressions created by the marks, bearing in mind their distinctive and dominant components. So just lingering for a moment there, you've got to bear in mind their distinctive and dominant components. And then it talks about when all other components of a complex mark are negligible, that's permissible to make the comparison solely on the basis of the dominant elements. And so we say that at paragraph 232, all the judge is doing is exactly what he's being told to by the authority, which is assessing the visual, oral and conceptual similarities, bearing in mind their distinctive and dominant components. And just in order to understand a bit better, the last sentence of paragraph 232, which is where he said the similarities are at a level which differs from that which has given the 615, 649 marks their distinctive character. We need to just look back at a bit of the judgment in relation to the marks themselves and the question of whether or not they were distinctive. Paragraphs 94 on page 27, where he's looking at, first of all, the 656, 664 marks, which are the stylized shorts marks. And he talks about one meaning of the word shorts with short form audiovisual content. And over the page, he says, in my judgment, the word shorts would be recognised by the average consumer as a description of a characteristic of the goods, at least in the case of sound, video and data recordings, etc. And then going on to paragraph 96, which we'll have to come back to in the context of the cross appeal, but just briefly, you'll see that he starts by noting that the triangle would be recognised by the average consumer as a play symbol, designating a characteristic of the goods, namely that they can be played. However, I need to consider the effect of the combination of the word shorts and the play symbol rendered in red and located within the O. In my judgment, the way in which the two elements are combined is such that the mark does not consist exclusively of indications which may serve to designate characteristics of these goods. The combination creates an overall impression which goes beyond a mere juxtaposition of two descriptive indications. So he's found that shorts is descriptive, he's found that the play symbol is descriptive, but he said when you put the play symbol in the O, that's the thing that gives the marks their distinctive character. And so that's what he's referring to at 232, where the complaint is centred, when he says that when he compares the marks. However, for the reasons I've explained, the word shorts is descriptive and the play symbol is an indication that the material can be played. So the similarities are at a level which differs from that which has given the 615, 649 marks their distinctive character. So again, we say he's just doing exactly what the case law tells him to do. Yes.
Apologies for asking a really basic question.
They're the best ones, my lady.
Where you took us to Iconics 174.
Yes.
That is a list of all the things you need to think about in assessing likelihood of confusion.
Yep.
As I understood the point being put against you, there's a prior step of assessing similarity. This is the step. So what you do? You then, well, that's my question. As I just bear with me. I understood the argument being put against you that purely when assessing similarity, you haven't got to likelihood of confusion yet. You shouldn't include distinctive character in it, albeit it comes in when you look at.
Well, if my lady looks back at paragraph 174, that is the list of all the things. So at the beginning, subparagraph A, the likelihood of confusion must be appreciated globally,
Yeah.
taking into account all the relevant factors. And so what generally you do as a judge is you, and as when you're making submissions, is you look at each of these factors. Factor D is you assess the visual, oral and conceptual similarities, and that includes that assessment according to the case law, bearing in mind their distinctive and dominant components. So we say it is perfectly legitimate as part of that assessment to bear in mind the distinctive parts of the mark. Now there is also...
So you say D correctly summarises the law.
Absolutely.
In relation to similarity
Yes.
per se.
Yes.
Not just in the context of the law.
Exactly. And I don't think there's any disagreement that D correctly summarises the law. It's really a matter of emphasis, and I'm afraid it's one of those points where what my learned friend is really saying is the judge gave too much weight to distinctive character. But I am now going to go, perhaps rather tediously, through the European case law, and I hope I'll be able to show that that's not making the point that my learned friend says it's making, and more importantly, when we get to the UK case law, we'll see that it's absolutely crystal clear that you take into account how descriptive the mark is when you're considering the question of likelihood of confusion. Now, at the very worst, and I don't accept this is what the judge has done, he's taken it into account sort of under the wrong head. You know, he could have taken it into account at another point in time. But I don't accept that actually, because subparagraph D tells you to take into account the distinctive and dominant, bearing in mind their distinctive and dominant components. So, the EU case law, starting with L'Oreal and OHIM, and that is at tab 5 of the authorities bundle, page 114. And in fact, we can go straight to page 115 just so that we can see what the case is all about. Paragraph 3, you've got L'Oreal files with OHIM an application for registration of the word mark Flexi Air, and Revlon has an opposition, one can see at paragraph 6, based on the existence of the word mark Flex. So Revlon says, I've got my mark Flex, I can stop you registering Flexi Air. And if we look at paragraph 23, which is on page 118, the applicant complains that the Court of First Instance had regard to the weak distinctive character of the earlier mark only when it assessed the likelihood of confusion between the marks at issue and not when assessing the similarity of the signs in question. At paragraph 25, it follows that the common element flex, which is, as the Court of First Instance itself held weak distinctive character, cannot have the significance which the Court of First Instance gave it in assessing the similarity of the signs in question. Furthermore, the other elements which distinguish the complex mark Flexi Air from the earlier mark should have been given more importance in that assessment, and the Court of First Instance should accordingly have rejected any similarity between the two marks in question. So basically, the complaint is that the descriptiveness of Flex should have been looked at in the context of assessing similarity. And then we go to paragraph 39. It says, in that regard, the Court of First Instance cannot be criticised for not having disregarded in its examination of the similarity of the signs in question the element flex, which is common to the marks, on the ground that the earlier mark is only of weak distinctive character. And it's important to bear in mind that the criticism is that it should have disregarded it, And then if we go to paragraph 41, the court repeats the point that I've already shown, my lords and my lady, that in the global assessment of likelihood of confusion, you've got to bear in mind the distinctive and dominant components of the mark. So it repeats that point.
But a bit more than that, it repeats the similarity of marks.
Yes. And then it says, and this is the bit that my learned friend likes, it follows that the distinctive character of the earlier mark cannot have the significance which the applicant argues it should have be given in the comparison of the signs in question, as it's not a factor that influences the perception. And it must therefore be held that the applicant has misconstrued the concepts by failing to distinguish between the notion of the distinctive character, which determines the protection afforded to the mark, then it goes on at 44 to repeat the fact that it has to be assessed globally. And then at paragraph 45, importantly, it says the applicant's approach would have the effect of disregarding the notion of similarity of the marks in favour of one based on distinctive character of the earlier mark, which would then be given undue importance. And the point here really is that the argument was that you should just disregard the similarity completely because the element was descriptive, whereas that is not the error that the judge has made in this case. Indeed, he hasn't made an error at all, because he does have regard to the similarity between the descriptive elements. I mean, most of paragraph 232 is about the similarity between the descriptive elements. And the point is, at paragraph 41, that it's not the lack of distinctiveness, it isn't something which can allow similarity to be disregarded. So it's saying you can't just get rid of the similarity component of the global assessment because the mark is descriptive, but that isn't what the judge has done in this case. And then if we go on to Adidas, which is the next case that is relied upon, that's in the next tab of the bundle, page 124. And we can look first of all at paragraphs 17 and 18. And this was a case where Adidas had the three-stripe mark, and there was an application for a two-stripe mark, and the Dutch court at paragraph 17 didn't like the three-stripe mark very much. It says at the end of the paragraph, however, given that stripes and simple stripe logos are generally signs which must remain available and do not therefore lend themselves to exclusive rights, the marks owned by Adidas cannot afford any protection against the use of two-stripe motifs. It then goes on to say at paragraph 18, Adidas takes the view that in the scheme of the system set up by the directive, the requirement of availability must be taken into account only when the grounds for refusal or invalidity provided for in Article 3 of the directive apply. So in other words, the court says when we're looking at the question of whether this mark should be allowed in the light of another earlier mark, we can take into account that the three-stripe mark is very descriptive. And Adidas says, no, you can't do that. You can only take into account that the mark is descriptive if there's actually an attack on the mark under Article 3. And turning over to page 135, essentially paragraphs 25 and 26, the court agrees with Adidas because it says that at paragraph 125, it's clear that the present reference to a preliminary ruling falls outside that framework. The framework it's talking about there is Articles 3 and 12 which are to do with validity.
Which paragraph are you on?
Paragraph 25.
25. I'm sorry.
25, sorry.
No, yep. Thank you. Accordingly, if it is established.
Yes. So what the court is saying at 25 is that because this is not a case about Articles 3 and 12, in other words, the articles about validity of the mark, but it's a case where it's a comparison between two marks, you can't rely on this question of the requirement of availability. I mean, my learned friend accepted when he looked at this that this is about the public policy point and whether you can take the public policy point into account. And paragraph 26 says that when a third party relies on the requirement of availability to argue its right to use a sign other than that registered by the trademark proprietor, the relevance of such an argument cannot be assessed under Articles 3 and 12 of the directive, but must be examined in light of Article 5 of the directive, which concerns the protection of the registered mark against use by third parties, as well as Article 6.1b. So in other words, you can't take into account the policy reason of trying to keep the descriptive marks free when you're looking at the question of a comparison between the marks, whether for the purpose of registration or for the purpose of infringement. And the court repeats again at paragraph 29 that it's a global appreciation test. But the reasoning in Adidas doesn't go to the more specific question that we're considering here, which is whether distinctiveness can be taken into account in the context specifically of assessing similarity. And finally, on the European cases, we've got the Bosch case that my learned friend also went to. And we say that this is very, very similar to L'Oreal, actually. He showed you, I think, so this is at page 461, tab 17. He showed you, I think, the Marks compressor technology, and that was opposed by the Mark compressor. And paragraph 47, which is the argument of BSH, I think my learned friend also took you to, which is the complaint that it leads to monopolisation of a purely descriptive indication. And then the substance of the decision is at paragraphs 56 to 58 on page 467. And again, I'm not going to read paragraphs 56 to 58, but it's all about whether you can disregard similarity completely. And it says you can't disregard it completely, but that's not what the judge has done in this case. I mean, he has had regard to the fact that the elements of the marks and the signs are the same. That's an important part of his reasoning in paragraph 232. Now, we'll all breathe a sigh of relief when we get to the UK authorities, which explain this so much more clearly. And it was very interesting that my learned friend didn't go to any of the UK authorities, but the judge did go to them. And so we can start with Planet Art. I'm actually going to take you to it, not in the judgment, but in the bundle. So we can see a bit more about what it was about. But it's at tab 19 of the authorities bundle. It's a decision of Daniel Alexander QC sitting as a deputy judge. And if you go to page 552, paragraph 147, you can see that the mark in issue, there's a table which shows the mark in issue on the left-hand side. That's the free prints mark. So I don't know whether you've got it in colour, actually. I think it was turquoise, with the butterfly and then the word free prints. And then on the right-hand side, those are the infringing signs, the photo box signs. So obviously one of the issues that the Deputy Judge had to consider was the impact that considerations of descriptiveness had on the question of infringement. And he looks at that from paragraphs 26 to 29, which is at page 521. And if I could just ask you to read paragraphs 26 to 29, please. So have my lords and my lady finished reading? Excellent. So just highlighting a couple of points. The explanation, the sort of common sense explanation as to why this matters is that given at the end of paragraph 26. A credible and dominant alternative explanation exists for the similarity in marks, which has nothing to do with their denotation of a common trade source. So in other words, when a consumer sees something that is descriptive, they are much less likely to think that it's connected with another business, and they're more likely to concentrate on small differences between the marks, and that's because you know in your mind that they're less likely to be the same thing because they're just both using descriptive words. I mean, the other thing that's important is at the beginning of the next paragraph, paragraph 27, which says the case law does not suggest that there are general rules as to how descriptiveness should be taken into account, but it's clear that it should be done. So you've got to take it into account somewhere in the assessment. And so, as I said earlier, at worst, what the judge has done is taken it into account in the wrong bit of the assessment. But as you'll see over the page, and this is the decision of my Lord Justice Burse many years ago, which clearly is not stuck in the mind, which says that you've got to consider it. And in particular actually says that it's necessary somewhere to focus on the impact of this aspect on the likelihood of confusion. And it talks about the common elements. And then we have obviously Mr. Justice Arnold acknowledging this, as he then was, and the Deputy Judge concluding that there's no hard rule that use of a descriptive term cannot lead to a finding that there is confusion, but they also show that such a case is harder to establish, and it has the impact of somewhat downgrading the significance of conceptual similarity in the evaluation of likelihood of confusion. So that's looking at it in the context of similarity, conceptual similarity. Since we keep mentioning it, my lord, I'm going to look at Nico Ventures now, which I did hand up earlier. Have my lord still got it? And it was an appeal from a decision of the Trademark Registry, that can be seen from paragraph 1, in which the opposition by the London Vape Company to the registration of the mark by Nico Ventures was upheld, and that was based on the earlier mark. And so the opponent's mark was the vapeco.co, which one can see on the first page of the judgment, and the applicant's mark is this vape and co mark on the next page of the judgment. And if we then go right forward to paragraph 26, there's some discussion of the hearing officer's decision, and in particular, it refers at paragraph 26 to the judgment of CJU in L'Oreal that we've just been looking at, and the point about disregarding the notion of the similarity of marks in favour of one based on distinctive character. So exactly the point that my learned friend is trying to run. And then the respondent says, it submits that the first sentence of this passage meant that the appellant's submission of law was wrong because it sought to give undue prominence to distinctive character, which is something that CJU was rejecting in that passage. I do not agree, my Lord Justice Burst says. I have referred to White and Mackey above. If the only similarity between two marks arises from common elements which have low distinctiveness alone and as a combination, then that tends to weigh against a finding of likelihood of confusion. Such a situation does not preclude a finding of likelihood of confusion, but it is a relevant factor, and in an appropriate case it may be decisive. And then it goes on at paragraphs, and maybe I could just ask my lords and my lady to read paragraphs 29 to 37, just skim through that, please. So we say the analysis is very similar to the analysis of the learned judge in this case, in that, first of all, at paragraph 34, my lord is looking at the fact that the marks do have a high degree of visual, oral and conceptual similarity, but then pointing out in paragraph 36 that the stylised aspects are entirely different, and that the concept of the two marks share is entirely down to their non-distinctive elements. It's the common concept which is non-distinctive, and therefore finding that there isn't a likelihood of confusion. And in particular, my lord, as I've already pointed out, makes the finding that L'Oreal doesn't tell you that you can't take into account similarity, doesn't tell you you can't take into account descriptive elements. And I mean, there's the further authority of lifestyle equities, which is in tab 24, of the authorities bundle at page 650. And you can see the marks in the head note, well, the mark and the sign. So the mark is Beverly Hills Polo Club, that's on page 650, H2. The sign is this other polo, Royal County of Berkshire Polo Club. And then the reasoning is in paragraphs, paragraphs 34 to 35 explain what the argument was on appeal. It was actually raised in the context of there being a crowded market, i.e. lots of other marks showing sort of polo players on horses. But then the reasoning about the distinctive character of the trademark is at paragraphs 36 to 39, and if I could just ask you to read those paragraphs, please. Now, I absolutely accept that here we're talking about it in the context of subparagraph H in the long list of factors, which is the one about the distinctiveness of the mark. But the point is, you've got to take it into account. It's a key factor. And the judge goes through this case law. We'll go back to the judgment now, because obviously that's what my learned friend is criticising. And at page 51, the judge cites at paragraph 178 the Planet Art authority and sets out the paragraphs that you've just been looking at. And then at paragraph 179, he sets out the lifestyle equities paragraphs. And there's no criticism by my learned friend of this citation of authority. And it couldn't be criticised. I mean, it's an absolutely fundamental proposition of trademark law and has been for a long time. And so when it comes to the global assessment, the fact that the marks have a low level of distinctiveness needs to be taken into account. So let's have a look at paragraph 240 of the judgment. We've looked at 232 already, which is the comparison of the marks and signs. And if we look at paragraph 240, that's where the judge makes his overall assessment of the question of the likelihood of confusion. And importantly, he starts by saying, I bear in mind that both contain the word shorts, which gives rise to visual, oral and conceptual similarities. So he absolutely takes into account the similarities of these marks. He does not disregard it. He has got it in his overall assessment. And then he takes into account things like imperfect recollection. He then goes on to talk about the distinctive character of the mark, which is low, and it arises from the particular combination of the word shorts and the play symbol in the O. And he says then, in my judgment, the average consumer would appreciate that the similarity between the 615649 marks and this composite sign arose from the fact that the marks are registered for and the sign is being used in relation to goods and services for which the word shorts and the play symbol indicate characteristics. Therefore, in my judgment, the average consumer would not mistake the sign for the mark. And so we say that this paragraph is a model of judicial drafting. He takes into account the visual, oral and conceptual similarities. It's the very first point that he considers. In the penultimate sentence, he's applying Planet Art, which is that there is a credible alternative explanation for similarity. And the suggestion which Sill makes in his skeleton, in their skeleton argument, that the judge airbrushed out of his assessment the similarities between the marks, can be seen to be completely wrong. They're there right at the front and centre at the beginning of the paragraph. And in our submission, Sill's real complaint on this issue of descriptiveness is that the question of descriptiveness is given too much weight in the global assessment. I mean, that's what their real complaint is. You should have given it similarity a bit more weight and descriptiveness a bit less weight. And we say that's a complaint about the balancing exercise carried out by the judge, which does not amount to a good basis for an appeal against a multifactorial assessment.
Going right throughout these paragraphs, the judge has got the numbering the wrong way around again.
I think so.
What's this paragraph? It's wrong in paragraph 232.
It's wrong in 240.
Oh, and 240. No, I think, yeah. So I think,
And
Certainly
239.
if you read 241 as well, I think.
yes,
I think this whole section is
yes, the whole
the wrong way
section.
around. Yeah.
Yes. I'm docking 1 mark, 99 out of 100.
Good, or you were given a draft you could have checked.
Yes, I was going to say, it's all our fault. None of us noticed. So apologies for that. So that brings me to the end of the point on descriptiveness and the criticism of polluting the assessment of similarity with distinctive character. We say it just when you look at the judgment, that is not what the learned judge did. So we've then got the question of various grounds on the overall assessment of likelihood of confusion. I mean, we say that they're even worse because, you know, that's front and centre an attack on a multifactorial assessment. But the first one, and I think perhaps the only one that's really seriously maintained now, is the placement of the play symbol. And that is indeed a complaint about paragraph 240, which is the one we just looked at. What my learned friend said in their skeleton argument was that the judge was wrongly identifying minute differences between the marks, and that didn't account for imperfect recollection and didn't give sufficient emphasis to the words. Well, in fact, the judge explicitly mentions imperfect recollection. He explains that the fact that the average consumer appreciates that the similarity arises from descriptiveness. And I mean, in his submissions, my recollection is that the point my learned friend concentrated on today was the point about the consumer being unable to discern whether there is a play symbol in the O of the sign complained of. So I think the point, he makes it in the skeleton argument, but I think that's the point he made on his feet today, is that the user of YouTube Shorts wouldn't be able to see, because it was very small, that in the mark which one can see above paragraph 240, that there isn't a play symbol in the O, so the O is empty. In my submission, this is a terrible point because the O is in fact empty, and so I just don't see where it gets the other side. But it certainly isn't a good enough point to say that this court can overturn the multifactorial assessment that the judge has made in relation to the overall likelihood of confusion. I mean, there simply isn't any attempt to identify why that conclusion can be attacked properly on appeal. Now that placement of the play symbol was paragraph 7 or ground 7 of Sills Grounds of Appeal. So I'm looking back now at page 250 of the bundle. Ground 8, I don't believe is being pursued. I don't actually understand it, so my learned friend will have to tell me what that is if he's trying to make a point about it, and I'll have to come back in reply. Ground 9, I also didn't understand my learned friend to be pursuing. There's a deathly silence from the other side, so I'm assuming I'm correct on both of those points. And then we get to ground 10, which is assessment of infringement of the 383 mark. And what this says in the grounds of appeal is that the judge erred in his assessment in that he failed to carry out any proper infringement analysis even on a contingent basis. And that is simply wrong, because if you look at paragraph 241 of the judgment, which is on page 67, at the end of that paragraph, he specifically says the 656, 664, that's wrong, that should say 615, 649. But more importantly for this purpose, and the 383 mark, each contain TV, which is absent from Google's composite sign, and so there are reduced visual, oral and conceptual similarities. So he did consider the 383 mark. So just another point that my learned friend raised, and I'm not quite sure which heading it comes under, but somewhere around overall likelihood of confusion, or possibly under the descriptive character point, it is that the judge wrongly adopted a single meaning rule contrary to interflora. And we say that simply isn't right when one looks at the judgment, because the judge was very clear that shorts had more than one meaning. I mean, he discusses that in the first part of the judgment that we looked at.
I
The
think
predominant
the point
meaning
against
is...
you, Ms. Lane, isn't that it has more than one meaning, it's sort of the opposite. It's that what the judge did is decided that there was a single meaning which had more than one meaning. What he should have done is decided that there were two meanings.
Well, if that's the way the point is being put, then that really just collapses into the point that we discussed earlier, which is the question of whether the judge should have found that there was this separate segment of the population which only understood shorts to mean traditional short films and nothing else. And for the reasons I've already explained, that is a bad point, because the judge, well, that point wasn't run at trial, there's no findings on it, and indeed, if anything, the findings of the judge that I've taken my lord to are contrary to that, particularly that finding we looked at in the context of passing off. So that brings me to the end of the points on infringement in relation to section 10.2. I was now going to turn to section 10.3, but I don't know if that's a convenient time to stop. I'm making reasonable progress, but I'm very happy to carry on, whatever's...
Well, let's carry on.
Excellent. Section 10.3. So there are two grounds under section 10.3. Ground 11 is the judge's failure to find that Sills' reputation had a mark for the purpose of section 10.3. And ground 12 is the judge's failure to find that there was detriment to distinctive character. So in the grounds of appeal, there's also an appeal on tarnishing, but that is not taken forward. So turning to the point about reputation under section 10.3, what we need to do is look at paragraph 255 of the judgment, which is on page 72. So just so that we can see what the judge's approach was, first of all, he said if the question is whether Sills marks were known by a significant part of the public concerned with any of the categories of goods or services for which the mark are registered, then the answer is no. And that is because even if you look at something like cinematographic films, only a very small part of the UK public concerned with such goods knew of any of Sills marks. So if you're looking at films, say, then the reputation isn't good enough. Then he talks about the Sazerac case, and I'm going to come back to that, which he says suggests that it may be possible to overcome the threshold issue of reputation by showing a reputation amongst a significant part of the public concerned with a subcategory of goods or services. However, for the reasons explained above, I do not regard short films as a proper subcategory of goods. And that's the point about it not being clear enough. And then the third thing he does in this paragraph is to say, however, he therefore doesn't regard Sills marks as having a reputation in the UK for purposes of section 10.3. However, if they do, it's amongst consumers of short films, and I shall consider matters on that basis. So just taking a step back, that means for Sill to succeed on section 10.3, they have basically got to overturn the judge both on this point about reputation and on the next ground, i.e. the ground about detriment to distinctive character. Now, turning to the point about the decision on reputation, Sill basically says that what the judge did wrong was approach the question by reference to the film industry and not by reference to their actual business in short films and the market in which they operate. And the relevant law, which my learned friend said that the judge didn't address, we submit is addressed, and it starts at paragraph 246 on page 68, which is actually a quotation from Sky Kick, but it's that quote in itself is quoting from General Motors, which is the classic case on how you establish reputation. And within that quotation, I just want to point out a few bits we say are particularly important. So first of all, paragraph 24, the public amongst which the earlier trademark must have acquired a reputation is that concerned by that trademark. That is to say, depending on the product or service marketed, either the public at large or a more specialised public, for example, traders in a specific sector. So there's reference to a specific sector there. Then at paragraph 26, it tells you that the earlier mark has to be known by a significant part of the public concerned by the products or services covered by that trademark. And then at the next paragraph 27 over the page, in order to look at whether the condition is fulfilled, you've got to take into account all the relevant facts, and they include the market share held by the trademark, as well as these other things: intensity, geographical extent, and duration. And he goes on to say, we raised the question of what was meant by a significant part of the public concerned by the products or services covered by the trademark. And the judge says that we submitted that the relevant public was that concerned by the goods and services across the breadth of the specification. I'm not actually sure that was quite what we were saying, but anyway, we were certainly arguing that you had to look at it across the particular goods and services that were mentioned in the specification. So you couldn't go down to smaller subcategories not mentioned in the specification. And in fact, we cited Sazerac brands in support of that. But what that says is that, well, perhaps I could ask you to read paragraphs 248 and 249. That's probably easier. Now, in a sense, this case, Sazerac, was against our broader proposition because we were trying to say you've got to show it across cinematographic films. And in Sazerac, they say you don't have to show it for whiskey. It's good enough to show it for bourbon. But of course, bourbon is...
I got that the wrong way round.
Yes, my learned friend also got it the wrong way round, so there we go. But anyway, the important point is that bourbon is a specific category of goods. I mean, bourbon has a specific definition. And the point that matters in this paragraph that the judge cites is the bit at the end where the judge says it would be illogical for the owner of the mark to have to prove a reputation in a field in which the mark has not yet been fully deployed or deployed at all if all that they were seeking to do was restrain infringement in a narrower field in which the mark had been used. So emphasis on the words narrower field. And then if we turn over to paragraph 250, 250 starts at the bottom of the page. The first point to make is that these cases provide no basis for a suggestion for a trademark to have a reputation. It needs to extend across the breadth of the specification. So against us on the main point is at 247. But in Sazerac, one of the marks was registered for beer as well as whiskey, etc. He says, if the mark has a reputation for one of the categories of goods or services for which it's registered, I cannot see why it matters for the purpose of being able to invoke section 10.3 at all, whether it also has a reputation for all the others. But the judge goes on to say, the decision of Fancourt J shows that in some cases it may be possible to invoke section 10.3 based on a reputation for a narrower category of goods than one mentioned in the specification. In my judgment, whether that is possible will depend inter alia on whether there is an identifiable subcategory of goods and the relative size of that subcategory compared to the category for which the mark is registered. In any event, the size and scope is relevant to the question of whether a link will be made in the mind of the average consumer.
I think that's probably time to draw stops and
Yes,
say
I
good
would.
morning. Very good. 10:30 tomorrow.
All rise if able.